afternoon. This is my second visit to the Harrow branch. I was here in 2010 also speaking on Islamic finance. And the reason I was playing with my phone just then wasn't because I was checking the football results or anything. It's because I'm recording this presentation, and if the technology works, what I will eventually do is put on my website a self-advancing PowerPoint presentation which has the audio and has the slides, so you can simply watch it. So if there's any friends who wanted to be here but couldn't be here, if you tell them about it at that stage, they'll be able to watch it, obviously for free. The only thing is that they can't ask any questions. After a bit of preamble, what I want to do is to explain why Islamic finance exists, how it's done, why the way that it's done potentially causes quite serious tax problems in the UK tax system, how the UK tax system has adapted to deal with those problems, and then a little bit about the residual areas where there are still difficulties. I'm going to cover direct taxation, but also SDLT, and just a little bit on VAT to explain the concepts behind it. You don't spend 35 years giving professional tax advice without worrying every single day whether you're going to be sued. And I never accept any responsibility for anything that I say in a presentation. So if you do anything or don't do anything as a result of what I've said, it's entirely on your head, and I accept no responsibility for it at all. This is not professional advice. A little bit about me, just the relevant bits. I was head of Islamic finance at PricewaterhouseCoopers in the UK, as well as being part of our global Islamic finance leadership team. And by background, I'm a chartered accountant, chartered tax advisor, and associate member of the Association of Corporate Treasurers. And it's worth keeping a note of the address of my website, because there's an Islamic finance section in that website which already has quite a lot of presentations that I've given, articles I've written on Islamic finance. So there's an enormous amount more you can learn just from there. A bit about the history of the legislation. The UK has had relief from the double charge, and we'll see what that double charge is later on, to SDLT from the very beginning of SDLT. We didn't start changing our direct tax law until 2005, and that was done specifically because somebody was starting the first ever proper Islamic bank in the UK. Prior to that, some Islamic banking had been done inside conventional banks, and the tax was dealt with on a sort of wing and a prayer, private deals with the Inland Revenue, etc. But at the time that people wanted to set up fully licensed Islamic banks, there was a recognition that what we needed was proper tax law for it. The tax law rewrite project, which I absolutely hate, has split the legislation into two parts: that which applies for corporation tax, which is in CTA 2009, and that which applies for income tax. The text is basically identical, and for practical reasons I'm only going to cite the CTA provisions unless it's specifically relevant to mention the income tax provisions. So why Islamic finance? Islamic scholars object to several things, of which the most important is riba. Riba is an Arabic word. It occurs several times in the Quran when God is completely damning about riba. And riba is generally understood by most Islamic scholars, although not all, as meaning any kind of interest on a loan, no matter how small, no matter how reasonable. So some people argue that it applies only to excessive interest, but the majority view of the Islamic scholars who express opinions on these things is that it applies to any level of interest. And that's the most important practical prohibition. But there are some other prohibitions as well, which I want to mention for completeness. Gara is an Arabic word which means high level of uncertainty, whereas mazir is an Arabic word which basically means created uncertainty, like basically gambling. So, and then another thing which is prohibited is selling things that you don't already own. Because if you think about it, if you say, I'll sell you my car, the price is £500, pay me now, but I haven't seen your car, I haven't inspected it, I don't know what your car looks like, it's a bit of a sort of pig in the poke. Conventional insurance is also prohibited for two reasons. First of all, insurance companies, when they take your money, they invest it typically in interest-paying bonds, and clearly investing in interest-paying instruments is considered prohibited. And they invest it in equities of companies, some of which may be doing sinful things, like running casinos. There's a more subtle reason why insurance is prohibited, because of course those two things would be quite easy to fix. You don't buy bonds and you don't buy shares in bad companies. And that is the inherent uncertainty of the insurance contract. And I'm mentioning insurance basically for completeness, so you can understand why some Muslims might object to insurance. There are ways of doing it, which I'm not going to talk about tonight, and in particular I'm not going to talk about tax, because there are no tax issues presented by this. Whether you're running an Islamic takaful company, which is the Islamic phrase for sort of quasi-insurance, or you're running a conventional insurance company, the tax issues are the same basically. So, having said what you can't do, the next question then is, what can you do and how do you do it? Let's start with a domestic mortgage, which is a thing that people very commonly want to do. How do Islamic banks do mortgages? The typical arrangement is that you have a seller who's got a house that he wants to sell. Let's say the buyer has got 25%, equivalent to 25% deposit. What happens is that the buyer buys a quarter of the house from the seller, while at the same time the bank with which you've pre-agreed this buys the other 75%. So the seller's happy, he sold 100% of the house. You own 25%, the bank owns 75%. You're the only person who moves in. The bank rents you the 75% of the house that you don't own. And that rent can be anything, and in practice the rent is normally fixed by reference to LIBOR, so LIBOR plus a margin. And that's perfectly okay, because you're only using LIBOR as a reference for calculating a rent. You're still paying rent to occupy land, you're not paying interest. And then over time, either on a pre-agreed schedule, which corresponds to a repayment mortgage, or totally flexibly, which is what corresponds to an interest-only mortgage with you having the right to pay it off when you like, you buy extra pieces of the property from the bank. And obviously, as your percentage ownership increases, the amount of house on which you're paying rent goes down. We'll talk about tax issues separately. You're a customer, you want something which you can't afford to pay for. A physical thing like a car or a machine. What the bank does is buys it and sells it to you and says, you can pay me later. You pay the bank later. In this case, the bank marks it up by an extra 100 and you pay in 2 years' time, which obviously corresponds to 5% simple interest. But what you're paying is extra price to buy the machine. You're not paying interest to the bank. Suppose you wanted money rather than a thing. Typically what will happen here is that the bank will buy something, and the most favourite commodity is copper, held in a terminal market, but it could be any commodity with just a few exceptions. Gold and silver are prohibited for religious reasons, but otherwise any commodity will do, but typically it tends to be copper. The bank buys it for 100, sells it to you for immediate delivery but delayed payment. So you pay the bank 105 in 12 months' time, but you get ownership right now. And because you've got ownership right now, you can sell it immediately back into the market for what it's worth, which is 100. You've now got 100 today in cash. And in 12 months' time, you'll pay the bank 105. But you're not paying interest to the bank. You are paying the bank 105 for the copper that the bank delivered to you today. a structure that corresponds in economic terms to a bank deposit. You've got money, there's a bank, you hand over your money to the bank and the bank invests that in some kind of commercial venture, normally the bank's own operations, and the bank manages that and it pays you a share of the profits. You're not being paid interest, you're being paid a share of the profits that the bank is earning from its activities with that money. And of course the bank's activities themselves do not involve lending money at interest, because this is an Islamic bank. They'll involve transactions like the mortgage we talked about earlier, or those murabaha transactions that I showed you earlier. Those are commercial ventures. Another form of deposit, slightly different contract in legal terms. I'm not going to go through Arabic contracts in great detail, but the previous contract was a mudaraba contract where there is an agent who manages, where the investor bears all the losses. Here you've got an agency with both parties sharing the profits. The bank again does the managing, and this is typically used for interbank deposits in the London market. So the investor gets paid a share of the profits, normally a predefined share unless the venture is totally loss-making. And a lease, straightforward transaction. The bank buys something that you want to use and rents it to you. Ijara is the Arabic word for this contract, but it's a leasing contract. Yes?
You mean the previous two ones you mentioned?
The wakala and the mudaraba.
The agent. So the bank is the agent.
The bank is legally the agent. These contracts are modern versions of contracts that have been around in the Muslim majority world for centuries. So a mudarib is a kind of agent, a wakil is a kind of agent. And I'm using agency because I'd rather use modern English law concepts rather than too much Arabic.
Can I ask you one question?
Yes, certainly.
You said gold and silver are both prohibited.
For this transaction, yes. Because it comes from the original Islamic teachings, the sayings of the Prophet. There are certain things you can do with copper and other commodities in terms of buying and selling that you can't do with gold. Gold is equivalent to money. In the same way that you are not allowed to lend me money and have me pay you more money in the future because that's interest, if what you're doing is selling me gold at a markup, that is considered as interest on money, because gold is money. Gold is thought of as money rather than being thought of as a commodity under Islamic law. So why does this lead to tax problems? Let's go back to the mortgage. This house, 75% of it is being sold twice. First of all, the bank buys it, and then over a period of time, in thin slices or thick slices, it will sell you that house. So that 75% is being sold twice. Does it get clobbered for SDLT on both occasions? Because if it does, that means that the SDLT on an Islamic mortgage is quite a lot higher, almost double what the SDLT would be on a conventional mortgage. The purchase and resale transaction, where you're buying a physical thing for delayed payment. How do you get a deduction for the extra 100 that you paid? Now, if it's a capital allowance item, it's presumably part of the capital allowance's cost, but that means that 1100 that you're paying, including the extra 100 that if people were paying interest, they'd spread that 100 interest over 2 years. But in your case, you might be amortizing that extra 100 over the entire capital allowance life of the asset. And that's if it's an asset that qualifies for capital allowances. If it's an asset that doesn't qualify for capital allowances at all, how on earth do you deduct the extra 100 that you've paid if you're in business? And similarly, if the bank is buying and selling something, does it have to pay? Does it get taxed on its 100 profit immediately? Interest, clearly the bank would spread over the time period of the loan that it was earning the interest. But does it get taxed on the 100 immediately? So unresolved questions. This transaction where the customer buys something for 105 payable in 12 months time, but then sells it for 100 immediately, the customer is getting 100 but is suffering a £5 loss. You're buying something for 105 and selling it for 100. is that 5 deductible? It's clearly not a trading transaction. Nobody goes into trading transactions knowing for certain they're going to make a loss on it. This mudaraba transaction, where the bank acts as an agent, investing the money, paying you a share of the profits, who's taxable on that commercial venture? And if the bank is paying out a share of profits, why is that deductible to the bank? Is this a partnership for tax purposes? Unresolved questions. And what's the nature of the income that the investor receives? Is it, to use really old language, and I'm now going to show my age, is it Schedule D Case 1 income? Is it Case 3 income? Unresolved questions. And in UK tax law, which is very legalistic, these kinds of questions really matter. Same with the Wakala transaction. What's the nature of the shares of profits that these parties are being taxed on? And a subtle point here, which also applies to the Mudaraba transaction, suppose we've got a foreign border in between. Suppose the investor is overseas, either for this transaction or for the Mudaraba transaction. If the investor is overseas and the bank is here, when a foreign investor sticks money in a UK bank and earns interest, the UK doesn't try to tax them. However, is this a permanent establishment situation where the agent in the UK running a commercial venture in the UK is creating a permanent establishment of the foreign investor? Unresolved questions. The leasing one, I can't see any problems. It's just for completeness. Not every Islamic finance transaction automatically gives rise to problems. I don't see any issues on the leasing transaction that are different from any other leasing transaction. And this structure, the tradable bond, which I think I skipped over earlier. Let me go through, first of all, what the tradable bond structure does, because it's a really important structure, and then we'll talk about the potential tax problems. Regular companies just issue tradable euro bonds. It's a piece of paper which says this company has borrowed £1,000 payable in 5 years' time. In between, it'll pay £5 a year interest to whoever happens to own the instrument. That's a tradable bond. You can't do that in Islamic finance. And about 20 years ago, the Malaysians came up with a structure that fulfills the same economic purpose, but without having any interest-bearing loan. And the best way to talk about the structure is to illustrate it. Let's say you've got an owner here who wants to raise £100 and has a building. What it does, it creates a special purpose vehicle, a company owned by a charity. The company doesn't do anything else, and it agrees to sell the building to the special purpose vehicle for 100. How does the SPV pay for the building? It issues certificates to investors for 100. And these certificates are an undivided ownership interest in the building and anything that the SPV might do with the building. That's what the certificate says in legal terms. This is a fractional ownership certificate in relation to that building owned by the SPV. So that's how the SPV gets 100 to pay the owner. How does the SPV ever generate any income? It rents the building back to the owner with a lease, and the owner pays, for example, £5 a year of rent. I like to keep the arithmetic simple, which is why the numbers are so small. So now the SPV is receiving £5 a year rent, but that rent doesn't beneficially ultimately belong to the SPV, because under these certificates, the real ownership interest in that building belongs to the investors. So the SPV pays out the 5 every year to the investors. And then in 5 years' time, when you want to unwind, while the diagram doesn't show it, we reverse the transactions. The SPV sells the building back to the owner for 100. The owner pays the 100 to the SPV. The SPV doesn't keep that 100. That belongs to the people who have the certificates, who have the ownership interest in the building. So the SPV pays out the 100 to the investors. Deal done, finished. But that potentially gives rise to all kinds of tax transactions. First of all, for SDLT purposes, we've got a sale of the building to the SPV, we've got another sale back from the SPV to the owner. We've got a lease, which may also be an SDLT transaction. We've got two disposals potentially for capital gains tax when the building, which might have been an appreciated building, is sold by the owner to the SPV, and also the sale back by the SPV to the owner is potentially a CGT transaction as well. And of course there's the question about the nature of the SPV's payments to the investors. Are they deductible to the SPV? Because it's pretty obvious the SPV should be taxed on the rental income, but is it entitled to deduction? And how do you apply withholding tax? What's the nature of the income being paid out to the investors? If that payment out is equivalent to rent, and if you're cross-border, then you should always have a withholding tax. So all kinds of issues. So against that background, the UK has brought in some very specific tax law to deal with Islamic finance. And let's start with the basic approach. The UK's goal is very straightforward, that equivalent transactions should receive equivalent tax treatment. You don't want to favour Islamic finance, which some countries overseas do, like Malaysia. They go out of their way to give tax benefits to Islamic finance compared with conventional finance, but Malaysia is a country which is 60% Muslim and is trying to develop its Islamic finance industry. But the UK's approach is simple. We want to create a level playing field. No advantages, no disadvantages. A really fundamental point is that the UK does not want to bring religion into UK commercial law, UK tax law. We can't possibly depend on whether something is genuinely Islamically approved or not to decide how we're going to tax it, because people's religious opinions might differ. We don't want to discriminate in our tax law between different groups of people depending on what religion they are. So it's totally religion neutral. And in fact, you open the yellow book or the orange book, you will not find a single mention of Islamic finance or any of these Arabic structures I've been talking about. You will find them in the explanatory notes when they publish the Finance Bill, but you will never find it in the text of the Finance Bill or the Finance Act. We also wanted to avoid affecting everybody. For example, everybody who does a credit sale. We don't want them to find that they've got complicated tax rules applying just because we brought in some law for Islamic finance. And the deeming approach I'll talk about when we actually get to it and these specific obstacles. So as I said, it has to be completely neutral, and so in our tax law we have defined certain kinds of transactions. And if you didn't know anything about Islamic finance, you wonder why on earth somebody was defining these transactions. But if you do know about Islamic finance, you can instantly spot what they're trying to do. If you read the rules for profit shared agency, you can tell straight away it's meant to be a wakala contract. And similarly for diminishing shared ownership, as soon as you look at that, you know it's a diminishing musharaka contract. Musharaka, by the way, is the Arabic word for partnership. And similarly with a structure called the investment bond, which used to be called alternative finance investment bond, as soon as you look at the rules in the tax law for that structure to qualify, you know it's meant for a sukuk. So let's look at the direct tax rules first. And I've taken here one section from CTA 2009, section 503. And when you start reading it, it tells you what this section applies to. You need a first purchaser and a second purchaser. And critically, one of those has to be a financial institution. Maybe both, but at least one. Otherwise, this section does not apply. And this is how you avoid bringing every possible credit sale into these rules that I'm going to talk about. And under these arrangements, the first purchaser, think of the bank, buys something and sells it to the second purchaser, namely the customer. Think of that machine. And it sells it immediately, apart from a subsection 2, which we'll look at but we're going to ignore, because in practice it always is immediate. And there's a deferral of the price. The deferred price is higher because there's a markup, and that excess equates in an economic sense to a return on money at interest. We're not saying it is interest, we're saying it equates to interest. As I said, this bit I'm going to ignore. This is for a rather hypothetical situation where the bank keeps a stock of things to sell, which in real life they just don't. The banks only buy machines or cars when customers want that particular machine or that particular car. Banks don't keep a stock of machines to sell. So the first purchase price is what the bank's paid. The second purchase price is what the customer has paid is going to pay to the bank. And that's a definition just in case there was any doubt. So the key point is that you've got a markup which is equivalent to interest. And elsewhere in the legislation it says that markup is called alternative finance return, which is a technical name that in the tax law for that return, and alternative finance return is treated for tax purposes as if it were interest.
So it defeats the purpose. So what's the
Pardon?
It defeats the purpose if it's treated as interest.
It is treated for tax purposes as if it were interest. The UK government is not saying it is interest. And the reason it doesn't say it is interest is that that would upset an awful lot of Muslims doing the transaction. And it isn't interest, it is a markup. As a matter of law, it is a markup on the sale, but it is economically equivalent to interest, and it is taxed in the same way that interest is taxed. But it's not. But the law does not say it is interest. And as I said, the way you avoid affecting everybody is by always requiring a financial institution, apart from the rules for sukuks, where you have that SPV instead. What's a financial institution? Exactly what you would expect. Banks, building societies, insurance companies, takaful operators, SPVs of that kind for certain transactions only, and quite critically, wholly owned subsidiaries of banks or building societies. So this deeming approach I mentioned before, it's the markup, the expense is treated for tax purposes the way that interest is treated, but the law is not saying it is interest, and it's treated as it in the same way that interest is treated for both sides to the transaction, the financial institution and the customer. So the bank now will spread that profit over the life in the same way that it would spread interest over the life of the transaction. The customer can deduct that 100 markup over the 2-year life of the transaction in exactly the same way the customer would deduct interest. The other 1,000 will be the capital allowance cost of the machine if it's a machine qualifying for capital allowances. So you get exactly the same tax answer for Islamic finance in that transaction as you would for conventional finance. The specific obstacles. UK tax law has always had a lot of provisions designed to stop people treating equity finance, designed to stop you writing a contract as if it was debt, where it's really equity. So profit participating loans, the interest on those has always been treated as a distribution in general. And that provision used to be in ICTA 1988, section 209 2E3, and that rolls off the tongue if you spend a lot of time looking at that provision. There's a specific override to that rule in the legislation relating to Islamic finance. So for the transactions to do with wakala and mudaraba that I showed you, but I'm not going to go through the legislation in detail, you'll see that there is a specific override so that alternative finance return is never treated as a distribution. It's treated for tax purposes as if it was interest, provided it meets all the definitions. And after the tax law rewrite, section 209 is spread over about 8 sections, but again there is a specific override in CTA 2010 covering alternative finance arrangements. And similarly with sukuk, as I said earlier, these are fractional ownership interests. And before 2007, if you tried creating a sukuk structure in the UK, it would have fallen apart for all the problem reasons I outlined earlier. Namely that you couldn't tell the nature of what the SPV was paying out. It was most likely a distribution, but not guaranteed. It was just very unresolved. And cross-border payments, was it a payment of rent? Was it something else? Again, totally uncertain. And FA 2007 started the process of creating some tax law for sukuk, but only did half the job. It dealt with the nature of the income that's paid out and the definitions of how you create a sukuk structure, the sale of an asset from the owner to the bond issuer, etc. There's quite a lot of definitions in FA 2007 about how you do it, but it dealt with the payment out. It had an override for section 2092E3, but it was incomplete for reasons we'll look at. And that legislation, which was in 2007, has now been rewritten in CTA 2009. But the rewrite doesn't change the underlying tax law. It simply uses what is supposed to be simpler language, which is, as far as I'm concerned, is simply longer language and less clear language. I hate the tax law rewrite. When the structure was brought in 2007, it was called an alternative finance investment bond. For reasons I do not understand, when they did the tax law rewrite, they decided to call it an investment bond. Somebody obviously thought that it was shorter if you took out the words alternative finance, but it is the same structure. The oddity is that the name alternative finance investment bond is still used in the regulatory rules, because quite apart from the tax law problems, the other problem associated with sukuk with this is that if you've got shared ownership of a building between all the investors, have you got a collective investment scheme? Because if you've got a collective investment scheme, there are all kinds of regulatory rules that apply to collective investment schemes, licensing, who can buy things in it, etc., that would be a nightmare. And so again, nobody could issue sukuk in the UK until the government had fixed the regulatory rules, which they did in a particular a couple of statutory instruments, which I've named there. And in the regulatory rules, they used the term alternative finance investment bond because that's what applied in those days. When they renamed it for tax purposes, they didn't rename it for regulatory purposes. So the same thing now has two different names, whether you're talking tax or talking regulation. And the key thing is that the periodical payments are treated as interest, but that didn't solve the SDLT problem. It didn't solve the capital gains tax problem. The SDLT problem and the capital gains tax problems were both fixed in FA 2009 Schedule 61. So between FA 2007 and FA 2009, the tax law was on the statute book for how to issue a sukuk. Nobody issued one because you couldn't, not without shooting yourself in the foot on capital gains tax and SDLT. But in 2009, they finally fixed it, and they've effectively abolished the SDLT on these transactions completely. Provided you meet all the rules, provided there's a sort of guarantee given to the government about paying the SDLT if the rules get broken, but essentially, provided you comply with the rules, there are no SDLT problems anymore on issuing the sukuk. And similarly, there are no CGT disposals involved. The transactions get disregarded for CGT purposes. They also get disregarded for capital allowance purposes. So if this was a building that qualified for capital allowances, the owner would carry on getting capital allowances all the way through. So a bit more about SDLT. SDLT was the first part of UK tax law to be amended for Islamic finance, to eliminate the double SDLT charge on Islamic mortgages. And that was there right from the beginning in FA 2003, but only for individuals. Only for individual purchases. It was extended several years later, from memory around about FA 2006, for partnership purchases and corporate purchases. And it's not limited to residential property, it includes commercial property as well. And of course, once it did that, it created tax avoidance opportunities. At its simplest, suppose you want to try to avoid, this doesn't work by the way, I mean the loophole's been blocked a long time ago, but suppose you wanted to avoid SDLT on a building that you own. if you sell this building to an SPV, a wholly owned subsidiary of a bank, which rents it back to you, you would have, if you look at the rules for abolishing this double SDLT on a mortgage, you would have qualified for that, because it's basically rather like getting a second mortgage on a house that you already own. That's what the transaction is doing. But now, of course, the bank has got this 100% SPV, which has got the building inside, rented to you, and now the bank can sell that company, having enveloped the building inside it, to anybody else. You know, it seems too good to be true, but there really were avoidance opportunities that simple until the loopholes got blocked, which they did. And by this time, I was actually involved in running PwC's stamp duty land tax practice as well, and so we were involved in writing the disclosure of tax avoidance schemes disclosures, because of course everything like this you had to disclose, but there were delays between being notified and the schemes being blocked. So let's go on to Project Blue, which I was asked to talk about specifically. It's sexy, it's big, and it's still unresolved. And it's famous because it involves the Chelsea barracks. I mean, Islamic finance does I was approached by a journalist a couple of weeks ago who's doing a research project, and she said to me, her research project is about why Islamic finance doesn't get enough press coverage in the UK. And I said to her, in relation to the size of the industry, when you look at how small it is, and the UK Islamic finance industry is maybe $18–20 billion worth, total asset size, that's all. Compare that with the size of conventional finance in the UK, Islamic finance actually gets more press coverage than it's entitled to in relation to its size, because it's different, it's new, it's sexy, and involves some quite famous transactions like the Shard or Chelsea Barracks. So in Chelsea Barracks, the Secretary of State for Defence owned Chelsea Barracks and agreed to sell them, straightforward commercial disposal, to Project Blue Limited, which was going to develop them. And I can't remember who owned Project Blue, various investors, but essentially that is the entity that was going to buy it and then develop it. And it was going to be financed, and is being financed by this Qatari bank, which Mazraf Al Rayan, which we'll just call MAR, and that's going to finance it. And because this is a tax lecture rather than a criminal whodunit plot, let's address right now the sort of punchline. It's obvious to me, if you think about that transaction and think about the equivalent conventional transaction, that only one person should be liable for SDLT, and that person should be Project Blue Limited. It's buying it. The bank is just providing finance. And the amount on which it should be taxed is the price it's paying to the Ministry of Defence. In other words, SDLT on 959 million. Easy. Unfortunately, the SDLT law at the time that these transactions were done simply didn't easily, clearly at all get to that answer, as we'll see when highly qualified judges start looking at it. So what did these parties do? Well, the Secretary of State for Defence didn't do anything complicated. They simply sold it, exchanged contracts, 20% on exchange, 20% on completion, and three more delayed payments. That's the deal between the Ministry of Defence and Project Blue. But let's look at the transactions between, so that's the first one, SSD to PBL. PBL, Project Blue Limited, and MAR, the bank. PBL contracts to sell this land to MAR, not for a sterling price, but for a dollar price, because we're talking about a Qatari bank. They live in Qatar. They think in a dollar environment. I mean, Qatar has its own currency, but nevertheless, they think dollars. So the transactions by the bank and PBL were all done in dollars. And so for 2.4 billion, it sold the land with a lease back, and the MAR pays the 2.4 billion in stages. 1.8 billion in fixed stages that mirror exactly the sterling amounts that PBL is supposed to pay the Ministry of Defence. Another $76 million when PBL is due to pay the SDLT, corresponding to what the SDLT should have been. And then some more payments of that purchase price to PBL corresponding to payments that PBL is due to make to the bank, because PBL, we'll see in a minute, is supposed to pay money to the bank as well, because it's going to rent the barracks back. And so these dollar payments add up to £1.25 billion in sterling. More transactions between MAR and PBL. MAR, having bought Chelsea Barracks, agrees to rent them back for 999 years and a bit. And there's a rent payable, which is a formula rent. And then on the 31st of January, which is when you get to completion date, the Secretary of State for Defence does transfer the land to PBL. The TR1 is the land registry transfer. And there's also a deed of clarification, because under the sale contract originally, there was sort of an overage payment. If PBL turned around and flogged the building straight away to the third party, the Ministry of Defence wanted a share. But the Ministry of Defence accepted that when PBL was flogging it to the bank, it wasn't really selling to a third party, that was a financing transaction. So the Ministry of Defence agreed that that didn't trigger the overage, and that's what this deed of clarification is, nothing more than that. PBL, as I said, granted the lease that they'd previously agreed to grant. On 31 January they did grant the lease, and they entered into what all the legal opinions call put and call options. And I've not seen the documentation, but I have seen other Islamic transaction documentation. In practice, these would not have been put and call options. They would have been purchase promises and sale promises, which have the same economic effect as an option, but they're not options. They normally use in Islamic finance something called a wad, which is an Arabic word, which means an unconditional promise. The reason they don't use options is that the Islamic scholars don't like options. They say that they're not Islamic, but they're happy with unconditional promises that have the same economic effect. And that's what I suspect they actually had. But as I said, the lawyers just call them options, and there's no harm in calling them options for the purpose of today's discussion. So the question is, who's liable to the SDLT? I mean, there are sales of this land all over the place. And on what amount? Because land's being sold by the Secretary of State to Project Blue for 959 million, but Project Blue is selling it for £1.25 billion. And the law is set out in section 45.3 FA 2003. That's the bit that deals with effective subsales. And in FA 2003 section 71A, which is the bit that deals with double SDLT and Islamic mortgages. And I'm not going to plough through the wording of the law in detail. And the reason for that is very simple. It's very unclear, as we'll see from when we look at the judgments, and it's been amended. It's been drastically amended to try to take away the problems that this transaction hit. So what happened? The first tier tribunal decided that PBL was chargeable. And remember, every one of the judges sitting in all these tribunals is an expert at reading tax law, very knowledgeable, and they come to completely different conclusions, which is a sign of just how badly drafted the legislation was. So the first tier tribunal decided that PBL should pay the SDLT on £1.25 billion, because they decided an anti-avoidance provision applied. PBL appealed to the upper tribunal, who decided that actually it should only be taxed on 959 million SDLT on that for a different reason. PBL went to the Court of Appeal and won completely. So PBL isn't taxable at all, but MAR is chargeable on £1.25 billion. However, the HMRC is out of time. They'd already agreed that MAR wasn't taxable and is out of time for reassessing it. HMRC was pretty upset, but the Court of Appeal refused to let them appeal to the Supreme Court. However, the Supreme Court has since allowed HMRC to appeal, and the Supreme Court judgment hasn't happened yet. The hearing hasn't happened. And my personal forecast, without having read any of the contracts, and without bothering to try to plough through the underlying statutes that said they're simply defective, is I think the Supreme Court, which has a track record on this, looking at other tax avoidance cases. I've actually had one case of my very own go to the Supreme Court about gilts and basically repo transactions involving gilts. The Supreme Court tries very hard to come up with a tax answer that makes sense. If there's a way of reading this law that makes sense, the Supreme Court will find it, and sometimes they'll find it even if it's not there, possibly. So my forecast is that PBL will end up paying SDLT on 959 million. That's just an educated guess. So there are still problems. The first problem, which is not on this slide, is simply that you have to have a financial transaction, a financial institution. So two companies cannot enter into an Islamic finance transaction with each other if they're just ordinary conventional companies, no matter how much they might want to. And even if they're both fanatically Muslim, they can't do it. The tax rules don't apply. You have to have a financial institution. That's just a nuisance. It's a function of the fact that all of this legislation was brought in originally with the expectation that it was for Islamic banks and to avoid complicating everybody else's life. Because if you wanted to allow two ordinary companies to do an Islamic finance transaction, you have to find some way of drafting the law that then didn't catch every other deferred sale agreement in the world. So let's look at some of the problems that still remain. Remortgaging. If you remortgage your house, there's no problem. It's a principal private residence. You can sell it without capital gains tax. There's no double SDLT. There's no SDLT on this transaction at all if you do it. However, if this is a commercial property, it's still treated as a disposal. No SDLT, but you've got a thumping taxable capital gain. Your pregnant capital gain suddenly becomes taxable. If you had done a conventional remortgage transaction, no CGT disposal. So there is no equivalence at the moment for this remortgage transaction between Islamic finance and conventional finance. The revenue know there's a problem. Yes?
Couldn't there also be a problem if you buy a property and do one of these Islamic mortgages in circumstances where you're obtaining the mortgage for the initial purchase? What I have in mind is a transaction where we've been instructed where purchaser exchanged contracts with a developer back in whenever 2011.
Yeah.
They're now completing, and they'll complete and subsell to the bank and get their SDLT relief and so on. But of course the property has gone up in value. If the property has gone up in value since the exchange contract, isn't he now making a disposal for CGT?
Your purchaser is making a disposal for CGT, but remember that they're not connected parties. So the developer and the bank are not connected parties, and I would say they are parties, they are dealing at arm's length. So provided that the price that you sell it to the bank is no higher than the price that you paid the original seller, even if the thing is worth more now, then you actually don't, I think you would not be paying capital gains tax. But normally when people do this transaction, they normally want to get more money. You know, in the same way that if you were doing this conventionally, you would maybe be taking out a larger loan than the price you'd originally paid for the property if it's gone up in value. People want to do that Islamically. And that's where you hit a problem, because then your higher sale price is your higher CGT disposal price. Yeah. So I don't think you're caught by the arm's market value transactions rules. Yeah. So if you did it only for the original cost number, then you'd be okay. But typically, this happens as a problem when the property is appreciated and you're trying to actually finance that appreciated amount. VAT. The issue on VAT is you've got supplies all over the place which don't arise in conventional finance. So take that transaction with copper whereby the customer wants money. conventional loan from bank to customer, there are no supplies of any kind other than a supply of money, which is totally VAT exempt. Here you've got a purchase of a commodity by the bank, you've got a sale of the commodity to the customer, and the customer is selling it again to somebody else. Similarly, you've got supplies taking place with the building. Never mind the SDLT, you've got, for VAT purposes, you've got supplies as well, where the building is being sold by the owner to the SPV is leasing it, which is another supply, and then finally there's a sale back of the building, which is another supply. So you've got supplies for VAT purposes that don't arise in conventional finance, because issuing a conventional Eurobond secured on the building in the hands of the owner would not have given rise to any supplies other than, again, totally exempt supplies of money and credit. And the approach of the UK is that there's no tax law for VAT on Islamic finance. And the reason for that is that VAT is a harmonised European tax at the moment, because we are still in the European Union. And there aren't enough countries that are interested in Islamic finance to get the EU to change its VAT law. There are more countries than just the UK who are interested in Islamic finance. France has brought in tax law to facilitate Islamic finance. In fact, they consulted me at one stage when I was at PwC, gratis, just for advice. Dublin has brought in some rules. Luxembourg is quite interested in fund management. Malta wants to be an Islamic finance centre. But in general, there aren't enough countries that are interested in Islamic finance to bring in harmonised EU-wide rules for Islamic finance. So the UK has proceeded on a sort of make, do and mend basis by issuing statements of practice, etc., customs notices. And essentially, the approach that we've taken is that the markup is the markup on effectively it's a credit sale transaction, and therefore the markup should be treated not as a supply of the goods but as a supply of credit, while there is still the underlying supply of goods, but only for the non-markup amount. And let's see, but that supply of goods still remains a taxable supply, subject to the rules for commodity markets. So let's look at this simple murabaha transaction before, where the customer wants a machine. The commodity, the bank buys it, sells it on to the customer, and there's a markup. That price that the customer is paying of 105, 5 of that is treated as an exempt supply of finance, and the other 100 is treated as a taxable supply of goods. So the customer pays VAT, and that customer has to pay 125 to the bank, but provided the customer's in business, he gets it back. And of course, in most cases of this kind, the VAT is purely a cash flow issue. The commodity murabaha transaction, where the customer is selling this copper onto a bank, the problem you get here is that unless it's all inside a commodity terminal market, where everything's in the terminal market and therefore never gets taxed, if the customer isn't in business, it can't make a taxable supply. In which case, the customer has paid VAT of 20 there, but can't make an onward sale. You can't charge VAT if the customer's not in business, which is a potential sort of problem. It depends on the nature of what's being done and who's doing it. But I spent a long time talking about using this kind of structure for student loans with HMRC and the Department of Business Innovations and Skills. And the transaction eventually got nowhere, partly because HMRC convinced themselves that there was a VAT problem, even though my VAT colleagues at PwC felt there wasn't a VAT problem because the terminal market rules should apply. So that's what I want to end. The UK is a global leader in amending its tax law for Islamic finance. Not only a global leader amongst European countries or liberal democracies, but even a global leader compared to many Muslim majority countries. In 2009, I was in Jakarta, and I gave a lecture to the central bank there on the taxation of Islamic finance. And what was really striking was having the Indonesians say to me that the UK, despite being a non-Muslim majority country, has made massive changes to its tax law, elimination of double STLT, etc., whereas Indonesia, which is a Muslim majority country, hadn't at that stage. They were lagging well behind. Singapore has simply copied our laws when bringing their rules for Islamic finance. You go to the Singapore tax legislation and you'll recognise the wording straight from the UK. UK really is a world leader in how to change your tax law for Islamic finance, especially without bringing religion into the tax law. So that's what I want to end. Questions?